All righty. I think we got just about everybody in. Okay, all right. Good afternoon, everyone, and thank you all for joining us for today's month of service presentation of child custody and support. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in this month of service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today is Ms. Myra Hippolyte. Also, on behalf of our partner with the Houston Bar Association, we have Ms. Grace Crump with McKiernan and Crump, who's going to be presenting the presentation for you today. But also included in the partnership is Lone Star Legal Aid, the Earl Carl Institute, Houston Volunteer Lawyers, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up a month of service. And basically what a month of service is a collaboration of these 8 different organizations that come together on a monthly basis and offer a variety of workshops, information, resources relative to community empowerment, asset building, asset protection, and the maintaining of generational wealth. So we know that there are a lot of underserved communities that are out there, or people that just don't know where to go, how to access certain information or resources, or know about services that are out there in the community that they can actually have access to, that can assist them in whatever issue, whether it's legal or otherwise, that can assist them with whatever, that they're going through. So we've been doing these workshops for the past several years. We used to do them in person. However, of course, we've had to adjust and adapt due to COVID. But this Zoom platform has allowed us to reach an enormous amount of people throughout the county, throughout the state. And because of that, these Houston Bar Association has also offered or sponsored legal CLE credits. So for any of our legal presentations that we do where you see a course number, you have the opportunity to take advantage of those free CLE credits for any attorneys that are joining us. I think that's about it. Okay. A couple of the things that I want to kind of go over is like our housekeeping or what have you. Information that is presented during our legal workshops is to be considered educational purposes only. It is not legal advice. However, we do encourage any of the participants that are in need or have civil legal matters that they'd like to have addressed or need assistance with to reach out to our legal service partners in that regard. In addition to that, this is an opportunity for you to ask questions of the legal experts that we do have presenting here today. But also we want to keep in mind, we want to try to protect your privacy as much as we possibly can. So please try to keep your questions to be as general as you possibly can and not divulge any personal detail information to get out there for everyone to have access to. We do record this session and send it out to all of the participants that do register for this presentation, as well as broadcast live on our social media platform at Amos Houston TX. So again, we want to try to protect your privacy as much as we possibly can. So if you are joining us on Facebook, please feel free to type your questions into the comment section and we'll make sure that they get read aloud at the end of the presentation. If you are joining us live on via Zoom, please feel free to type your questions into the chat box, or feel free to wait till the end of the presentation and unmute yourself, and then you can ask your questions directly of Ms. Crump. So with that being said, we are going to go ahead and introduce our partners and our presenter, and we will move right on into our presentation. So again, thank you for joining us this afternoon and continuing to come and support this month of service collaboration. Ms. Myra, would you like to introduce yourself first?
Yes, good afternoon. Thanks, Ms. Nia. Thanks, Ms. Crump. Good afternoon. My name is Myra Hippolyte, and I work with the City of Houston Department of Neighborhoods, Office of Neighborhood Engagements, under the direction of Division Manager Paul Green. On behalf of Mayor Sylvester Turner and Director Takasha Francis, we want to welcome you to the Month of Service Partnership. This partnership is all about giving back free information to all the Houston, Harris County, state of Texas community. We want to make sure that whenever you're going through whatever stressor in your life, we want to make sure that you have all the information in front of you to make the right decision. Many times we get the information after we went through whatever stressor, and we said, well, I wish I would have known. Well, the month of service partnership is all about giving you free information that you can make the right decision. We also want to let you know that we're having coffee and conversation in person and virtually on April 25th at Sunnyside, at the new Sunnyside Multi-Service Center on Reed Road. And I don't have
4410.
what is that?
4410 Reed Road. 4410 Reed Road.
4410 Reed Road. We are going to have the director of solid waste office talk to you about the new Clean Houston project. We want to make sure that each month we'll have a different speaker, and they'll speak for 1 hour. And then the second hour will be when you can have an informal conversation with all the City of Houston representatives. Also on, I think it's on tomorrow, we will, Nia and I will be at 601 Sawyer, Houston, Texas, 77009. And we will be able to pre-assess, if you're interested in being pre-assessed for free or low cost legal advice. Nia and I will be there from 10 a.m. till 1 p.m. So that's the Inspection and Public Service Division. We'll be out in the first floor. So if you're interested in talking to us about getting pre-assessed for any free or low cost legal services, come on down, and Ms. Nia Murray and myself will kind of pre-assess you and also kind of lead and guide you in the process. And that'll be tomorrow morning. So I've also added in the chat, and I'll also add it in the Facebook chat. Thanks everyone. You guys have a great day and stay safe.
All right, Ms. Grace Crump, go ahead and introduce yourself and go ahead and get started with your presentation.
All right, thank you, Nia. Thank you, Myra. And thank you for everything that you guys do for our community.
Thank
Let me go ahead and pull up. I've got a PowerPoint to kind of assist today. As I mentioned, my name is Grace Crump. I am with McKiernan Crump. I am board certified in the area of family law. I'm also a member of the Houston Bar Association Family Law section, as well as a number of other family law groups in the Houston area. All that to say, all I do is family law. You will not catch me arguing traffic tickets or any kind of criminal cases. So this is my area of expertise for sure. First things first. So one thing that everyone needs to always keep in mind is no two cases are exactly the same. When you go into the family law courts, and we have 10 different family law courts just in Harris County, the courts are going to be taking the cases up on a case-by-case basis. Just because your sister or your neighbor or somebody else that you know had a certain outcome in their case doesn't mean that you're going to have the same outcome. Even if it feels like the facts are the same, the cases are all different. We have a lot of rules in family law, which we'll kind of go over some of them, and pretty much every rule has an exception. Another thing to keep in mind about family law, we don't really have clear-cut winners and losers like there are in criminal law or in general civil cases. There's a lot of gray area when it comes to family law. Now, when it comes to custody, what we're talking about is several different things, and it's really apples, oranges, and bananas. So there's conservatorship, there's possession and access, and then there's child support. And although they are connected and, make up a fruit salad, if you will, they're not the same thing. And just because you get one thing in conservatorship does not mean you'll necessarily get something else when it comes to child support. Now, conservatorship, that is legal custody. When we're talking about conservatorship, you've probably heard people talk about being the sole managing conservator or the primary conservator. These are really titles. I always tell my clients, don't get hung up on the titles. We can call one parent a bird and call the other a worm. It doesn't really matter. What the most important thing is the rights and duties. Now, just by being a parent in the state of Texas and not being a murderer or a pedophile, you're entitled to some very basic rights and duties. Now, the court always has the ability to limit these rights, but these include things like being able to talk to the other parent about how the child's doing, accessing the medical records of the child or the school records, having the ability to talk to doctors, to dentists, to school officials. Another one of these that people tend to not know that they have is the right to attend school activities, including school lunches, performances, and field trips when it's not necessarily their day to have possession of the child. Obviously, during those days, you're allowed to go to the school. So if there's a school program, you're allowed to go see the child, but you cannot remove the child from the situation. Additionally, each parent has the right to be listed as an emergency contact for schools, for doctors. They also have the right to consent to surgical treatment in an emergency situation. So if there's been a car accident and you've had to rush the child to the ER in that kind of a situation. Next are the rights and duties during periods of possession. And so again, this can be limited by court order. And these include the right to reasonable discipline of the child, to provide the child, the duty to provide the child food and shelter. It also includes the right to direct the moral and religious training of the child. And that also includes not doing anything as far as moral and religious training goes. That's a parent's right that they, during their periods of possession, if they don't want to take a child to church or to any other kind of service, they are not obligated to. Now, the more substantial rights and duties, this is where the majority of the fight's going to come in any kind of custody case. And the ones that I have highlighted in bold here are the ones that people tend to fight over the most. And so we're going to spend a little bit of time going over that. The first is the right to designate the primary residence of the child. And that's where the term primary conservator comes from. What that means is that the default location for the child is going to be with this parent who has the right to designate the primary residence. The parent who does not get that right will get a possession schedule. And now nobody can force the parent who gets a possession schedule to actually exercise it. And so that's why the default location is going to be with the parent who has the right to designate the primary residence. The next major right and duty is the right to consent to medical, dental, and surgical treatment involving invasive procedures. This is in a non-emergency situation. So if the child needs to have their tonsils out or have tubes put in their ear. The next is the right to consent to psychiatric and psychological treatment. So if a parent thinks that their child has ADD and wants to put them on medication, that's psychiatric treatment. Or if a parent thinks that the child is just having a tough time with the divorce or with the custody fight that's going on between the parents and wants to put them in play therapy, that would be psychological treatment. The next, number 5, the right to represent the child in legal action. That doesn't come up all the time, but in the event that you take the child to Kroger, the child slips and falls on some water and you want to sue Kroger on the child's behalf, that gives the parent the right to do that. The next, the right to consent to marriage and enlistment in the armed forces of the United States. This is before the child turns 18. So if they want to get married before they turn 18 or join the army before they turn 18, they need the consent of one or both parents. Usually we do this as a joint. Additionally, it's my understanding that the federal government, when a child tries to enlist, they don't necessarily care what our Texas orders say, and they will usually still require that both parents consent for a child under the age of 18 to join the military. And again, this is from the child's under 18. Once the child turns 18, they are legally an adult and they don't need mom and dad's consent anymore. The next is the right to make decisions concerning the child's education. This comes up when it comes to things like whether to do private school or homeschooling as opposed to going to public school, or whether to put the child into AP classes, or ESL classes, making those types of decisions. Number 8, the right to services and earnings of the child. This really only comes up if your child is the next Hannah Montana or the next Justin Bieber. But in the event that they, hit it big, a parent has the right to manage their services and earnings. And then I'll jump down to number 10. This is a newer right and duty that has been added in. Is the right to apply for a passport of the child, renew the child's passport, and maintain possession of the child's passport. Now, with those more substantial rights and duties, there are several ways that we can do this. The first is to give one parent the exclusive right. And what that means is, for example, on the right to make medical decisions, if a parent thinks the child needs to have their tonsils removed, they get to make that decision. If they have the exclusive right, they don't have to talk to the other parent, they can just go ahead and do it. Sometimes the courts will say a parent has the exclusive right after consultation. And what that means is the parent with the exclusive right has to reach out and have a meaningful conversation about whatever issue it is with the other parent. And so, for example, if a parent reaches out and says, hey, I think Junior needs to have his tonsils removed, what do you think? And after the conversation, it's up to the parent with that exclusive right as to whether or not that surgery is scheduled and actually happens. Another way that we can do the rights and duties is the independent right. And so what that means is that each parent has the right during their periods of possession to make these decisions or consent to these things. Again, sometimes we add in there the caveat that it's done after consultation. So again, the parents would have to talk to each other beforehand, but at the end of the day, they each have the right to consent. Another one that we do is the joint right by agreement. This tends to be my preferred way to go in the majority of my cases, assuming that you have two parents that can, talk and work together. But it requires the agreement of both parties before a child can have any of the invasive medical decisions done, or can be subjected to any kind of psychiatric treatment, or making decisions as far as education. However, sometimes what we will also do in these is when you have the joint right by agreement, we also put in there what we call tiebreakers. So in the event that mom thinks the child needs to have their tonsils removed, and dad says, absolutely no way, I still have my tonsils, they should keep theirs. We'll put a tiebreaker in the order, and it's listed who it is. Usually in that kind of situation, it's going to be the child's pediatrician. And so if mom and dad can't agree on who or on what to do, they will then follow the recommendation of the pediatrician. For school, for any kind of educational decisions, usually we'll do the school counselor or principal, or maybe even a homeroom teacher, just kind of depending on what the setup of the school is. Now, there's a lot of presumptions. So I talked earlier about the rules in family law. And so we have a lot of presumptions that are just built into the Texas Family Code. The first one that we're going to talk about today is there is a rebuttable presumption that the appointment of both parents as joint managing conservators is in the best interest of the child. However, if there's a finding that there's been family violence between the parents, that removes the presumption. Additionally, if the court finds that the appointment of the parents as joint managing conservators would significantly impair the child's physical health or emotional development, that will rebut the presumption. This is just the basics of family law, so I'm really just talking today about two parents being the parties in a custody case. But certainly there are more complicated cases where you have grandparents involved, aunts, uncles, and even just third parties in general. But for today's purposes, I'm really just going to be sticking with talking about parents. And also I had highlighted the term best interest of the child. that is the number one consideration for courts and our family law courts whenever child custody is at issue or really anything involving the children. And that's the court's primary consideration. How do we figure out, though, what is in the best interest of the child? So here are some factors that the court looks at. This is a non-exhaustive list. That means, as you can see at the bottom, the last factor is any other relevant factor, which could really mean anything. But some of the things that the courts will look at is whether the physical, psychological, or emotional needs and development of the child will benefit from the appointment of the parents as joint managing conservators. The ability of the parents to give first priority to the welfare of the child and reach shared decisions in the child's best interests. Whether each parent can encourage and accept a positive relationship between the child and the other parent. Whether both parents participated in the child rearing before any lawsuits got started. How far apart the parents live. And then if the child is 12 years of age or older, the child's preference of who they would like to primarily live with. I will touch on this a little bit later. Some factors that the court cannot consider when deciding how to appoint the parents, whether joint managing conservators, sole managing conservators. The court cannot consider the marital status of either of the parents. They can't consider the gender of the parent or the child, the race of either parents or the child. The court also can't consider religion, including any unusual or abnormal beliefs. However, there is an exception, because again, pretty much every rule has an exception, but there's an exception for any illegal, immoral, or harmful beliefs. And then also the court cannot consider a party's immigration status. However, the exception to that is if the status has a negative effect on that parent's ability to parent the child. Next, so when a parent gets the right to designate the primary residence, the court will often put in place a geographic restriction. And that's because it's the public policy of the state of Texas that any parent who has been able to show that they can act in the best interest of the child and provide the child the safe and stable living environment should be able to be a part of the child's life and should be able to have a hand in raising the child. And so what the geographic restriction does is it sets an area where the child can live. One that's pretty standard is we say the child must live within Harris County, Texas, and contiguous counties. So that means any county that touches Harris County. So Montgomery, Galveston, Fort Bend, Brazoria, Waller, Chambers, and Liberty. I think I got them all. That way, everyone knows where the child's going to live. And so one parent can't pick up the child and move to Maine or move to even China. And that way, everyone knows where the child's going to be and everyone can stay close if that's what they want to do, if they want to be in the child's life and participate as a parent. With the geographic restriction, it can also get much more broad. I've had cases where we've had the geographic restriction being the entire state of Texas. I've had some where it's narrowed down to a specific school district or even a specific school. But like I said, for generally what you can expect as a standard geographic restriction, it's either going to be Harris County by itself or Harris County and any county that touches Harris County. Now, possession and access is what we consider physical custody, or you may have heard it called visitation. It's really the same thing. And we've got several different ways that we can do this. The first is the standard possession order. We also shorten it to call it an SPO. Now, this is what you have probably heard people talk about. People say it's every other weekend. It's not really every other weekend. It's the first, third, and fifth weekends. Just for note, recently the legislature changed so that not only do we have provisions for under 100 miles, but we also have provisions now for when parties live even closer, so under 50 miles, or provisions for when parties live between 51 miles and 100 miles apart. And again, for the sake of not complicating things, we're just going to talk about under 100 miles and over 100 miles. But really the difference is the closer the parties are, the more likely that they're going to have more time with the child. So your standard possession order, when a parent resides 100 miles or less apart, it's your first, third, and fifth weekends, starting Fridays at 6 p.m. and ending Sundays at 6 p.m. And it's Thursday, every Thursday during the regular school year, from 6 p.m. to 8 p.m., basically long enough to go to dinner. Then the non-primary parent gets 30 days in the summer. That can be broken up into 2 separate periods, or it can be taken all at once. And then holidays alternate. So one parent will have Thanksgiving. Whoever didn't have Thanksgiving will have the first part of Christmas, which will be from 6 p.m. on the day the child is released from school, and ending at noon on December 28th. And then whoever did have Thanksgiving that year will have noon on December 28th until 6 p.m. on the day before the children go back to school. Spring break also alternates. And then mothers will get Mother's Day weekend, fathers will get Father's Day weekend. And then on the child's birthday, whichever parent isn't already entitled to have the child that day, that parent has the option to come and pick the child up from 6 p.m. to 8 p.m. Again, basically long enough to go to dinner. Now, when parents reside more than 100 miles apart, the possession changes a little bit. They can still do either the first, third, and fifth weekends, from Sunday at 6 or Friday at 6 to Sunday at 6, or they can elect to do one weekend a month of their choice from Friday at 6 to Sunday at 6, with at least 14 days written notice to the other parent. Now they don't get to do different things each month. They have to decide what they're going to do and make that election, whether they're going to do first, third, fifth weekends or the one weekend a month. But once you make that decision, you're locked into it. Additionally, we don't have the Thursdays when parents live over 100 miles apart. And that parent, instead of only getting 30 days in the summer, would then get 42 days in the summer. Christmas and Thanksgiving alternate, just as they did when the parents lived closer together. However, a parent who lives over 100 miles or more from the child gets spring break in every year. And then Mother's Day weekend and Father's Day weekend and the child's birthday are the same as when the parents live closer together. Now, and backing up just a second, so the standard possession order, I also wanted to mention, it's also, we usually start this when a child turns 3 years old. So it's presumed that this is in the child's best interest when a child turns 3. And we'll talk a little bit later about what we do for children under the age of 3. Now, once children start school, in a lot of cases, what we'll do, and especially if the parents live closer together, is we will do an expanded standard possession order. And so what that means is it's still the first, third, and fifth weekends. However, the visiting parent is going to pick up from school on Friday and then return to school on Monday morning. And then during the summer, they go back to the 6 p.m. on Friday to the 6 p.m. on Sunday. Thursdays during the regular school year, they will have from the time school dismisses on Thursday and return to school on Friday morning. They get 30 days in the summer. And again, the holidays are the same, alternating Christmas, Thanksgiving, spring break, Mother's Day and Father's Day, go to that parent, and then the child's birthday. This cuts down, if you've got issues where you have two parents who just, for whatever reason, cannot really be around each other, or you're having issues with one parent, sending the child out of the house for visitation. When you're picking up and dropping off from school, this tends to cut down on a lot of that, because only during the summers and during certain holidays are the parents ever potentially coming face to face with each other. All the exchanges are occurring at the child's school. And again, there's a presumption that the standard possession order is in the best interest of the child, that it provides reasonable minimum possession of a child for a parent who is named as a possessory conservator or a joint managing conservator. Another thing that I didn't put in any of the slides, what I wanted to mention is at the beginning of pretty much of all standard possession orders and pretty much any possession order, there's going to be a little paragraph that says by mutual agreement of the parties. And what that means is that mom and dad can agree to do something different than what's in the order. It's always my hope that my clients will be able to just, throw the order in a drawer and never have to look at it again. However, I know for a fact that's not always the case. But if a parent, gets tickets to an Astros game on a day that they're not supposed to have the child, they can reach out and ask the other parent, hey, I know it's not my day, but I got tickets to the Astros game and these are really good seats. Would you let me take Junior? And the parents can agree and work outside the order. The order is what's in place and what the parents follow whenever they can't agree. And I always tell my clients, I encourage them to work outside the order, to work with the other parent for the benefit of the child. But just make sure that you put any agreements to deviate from the order in writing. So text message or email is fine, but that way, in case the other parent ever comes back and says, well, I never agreed to that, you got it in writing to say, look, we agreed that you would take the child to the Astros game on Monday instead of taking them, picking up from school on Thursday or whatever it is that they're going to do. Now, modified child support, modified possession order. So this is what we do whenever a standard possession order is just not workable or is inappropriate. So for example, depending on the parents' work schedules, so if a parent does shift work, or sometimes, with nurses, they'll work 4 days and then be off the rest of the week. That doesn't always work so well with the standard possession order. And so the courts can get creative. Also, if you have a parent who maybe for whatever reason hasn't seen the child in several years, and the child needs time to rebuild that relationship so they're not just jumping off and doing 30 straight days in the summer with a parent they hadn't seen in several years. You can do a slow workup to a standard possession order. Additionally, for children under the age of 3, now if there's an older sibling who's older than 3, usually they kind of just follow along and get caught up in the standard possession order. But if you have children that are all under the age of 3, then usually what we'll do is kind of a slow, just short, frequent visits. And so maybe not starting off at overnights, but just a lot of frequent day visits and eventually working up to a standard possession order, maybe once the child turns 3. And anytime that we do a modified possession order, the code still tells us that we need to have it resemble a standard possession order as much as possible. Okay, 50-50. This is kind of a hot topic right now. And I think a lot of people just like how this sounds, that they have, I have my child 50% of the time, the other parent has the other 50% of the time. Your courts really don't like doing 50-50. It tends to create more problems than it solves. You can understand, when a child's younger, so before they start kindergarten, it tends to work a little bit better. But once they get going to school and you're shifting every other week who's taking the child to school, especially once you get to the age of having to do homework and class projects and any kind of extracurricular activities, it can, like I said, it usually causes more problems than it fixes. It also takes some very special parents to make this work. They really have to want to co-parent and work together for the benefit of the child. It also helps if they live close together. When I say close together, I mean preferably in the same neighborhood or certainly within the same school district, because the parent's not going to want to drive, 30 minutes or more every day to get the child to and from school. Another misconception, I think, that why this 50-50 sounds so good to people these days is there's a misconception that 50-50 possession means that there's not going to be child support. And that's not the case. Next, just briefly want to touch on the topic of supervised visitation. This is something that we could probably spend the whole presentation talking about. If there's a situation where there's been family violence or any kind of neglect, a the court can order that a parent's visitation be denied completely. They can restrict it and they can limit it. We have several programs here in the Houston area that do supervised visitation. One of the more popular ones is through the Harris County Domestic Relations Office. They run the visitation center. And so if you have a situation where there's been family violence or for whatever reason, it's not appropriate for a parent to have unsupervised access to a child at the time, those are programs that you can enroll in that the court can order. And then I wanted to talk just briefly about child custody modification. And so again, this is a topic that we could probably spend the whole time discussing. But unlike a divorce, so when you have a divorce, and I know you guys talked about that last week with Judge Maldonado, when it comes to property, you really get one bite at the apple with that. Now, when it comes to any issues involving children, the law leaves the door open for parents to come back to modify if the order is not working or if they want to agree to something else. So the grounds for modification is the agreement of the parties. If mom and dad want to agree to either a change in custody or a change in visitation, we can do that. The preference of a child 12 or older. We like to say that the child gets a voice, they don't get a choice. And so at the age of 12 or older, they can speak to the judge and disclose to the judge whatever their preference is for who to be the primary conservator. They don't get to decide if and when they visit mom and dad. They just get to have a say in who they would prefer to primarily live with. The judge is not bound by the child's desires as far as that goes, because I'm sure you can imagine sometimes kids want to live with the fun parent who has no rules and there's no bedtime. But that might not be in the best interest of the child. Another ground for modification is the voluntary relinquishment of a child for at least 6 months. So if whoever was the primary parent under the prior order, if they have left the child with the other parent for a period of at least 6 months, then that gives the parent who currently has possession of the child the ability to come in and say, look, I need to modify this order because the child's been with me for 6 months or more. And then the last ground is a material and substantial change in circumstances. This can kind of mean a number of different things. It could be a change in job for a parent. It could be having to relocate. It could be a child who's been diagnosed with a learning disability. It's really any kind of material and substantial change in the circumstances of either a parent or the child. And because of that change, the order is no longer workable and needs to be modified. And again, with all of these grounds, the requested modification still must be found to be in the best interest of the child. And so I wanted to pause here because I know that's a lot of information, and see if we have any questions right now about either conservatorship or possession.
Hello? Oh, yes, go ahead.
I have a question. Why is 50-50 not in the best interest of the children when both parents should be in the life of the children? And why is attorneys always try to use standard possession order just to so they can make title deed funds of the parents, and mostly the father ends up paying the child support?
So as far as the standard possession order, that's what the Texas legislature has told us is in the best interest of the child. So as lawyers, we don't get to make the laws. We just have to help our clients, apply them to the cases and make sure that, the courts are following them. And so that's what the legislature has told us. Now, when it comes to another, misconception about the standard possession order is it's very close to a 50-50. So especially on the expanded, if you were to highlight the days that, let's say mom has the child in pink and dad has the child in blue, at the end of the year, once you take into account, all the Christmases, the holidays and summer, it really ends up being the difference of about a week. And then when you factor into the times when the child's at school or the child's sleeping, that time is really less. And it's a lot closer to 50-50 than people realize.
But the only reason they do it is to take, put fathers on the child support and, milk the system. And that's not fair. And I found the judges and the attorneys are just exploiting the system.
Well, again, I mean, that's the law. So the law says
Yes.
that we should be doing a standard possession order. And again, 50-50 doesn't mean no child support. So I've had cases where
agree.
parties have agreed to 50-50 and they still have to pay child support. One of them still has to
That's
pay.
correct. That's correct.
So I have a question in regards to the 50-50 and child support. So if it kind of still breaks down to be about 50-50, then why is one parent ordered child support versus the other?
And we'll kind of get into that a little bit more in the child support
okay.
section, but one thing we'll do, and it depends on the totality of the circumstances. So again, the court looks at everything on a case-by-case basis and takes a lot of different factors into consideration. But sometimes what we'll do, instead of having just guideline child support for one parent to pay, we will calculate what mom would have paid in child support based off of her income, compare it to what dad would have paid in child support based off of his income, and then whoever has the higher amount will pay that difference to the other party.
Gotcha. Okay, so there was another question here. Why does Harris County has 93.77 custody for moms? Gender discrimination is in family court.
That is correct.
That hasn't been my experience. I represent both a lot of moms and dads. I've had a lot of success representing dads. For a while, right before COVID, it seemed like every jury trial that we did in Harris County was coming back in favor of the fathers. You do have a right. So I think Texas is the last state in the country that allows you to have jury trials for family law issues. Now, a jury can't decide everything, but they can decide in custody cases who gets to be the primary conservator. And so sometimes that's an option in custody cases. However, I will go ahead and just let everyone know jury trials are very expensive because you need to set aside at least a week of time just for the trial itself, not even taking into consideration the prep time on that.
Okay. And that's it so far.
Okay. And one other thing I wanted to mention, so I mentioned earlier that we have 10 family law courts in Harris County. Something to keep in mind is we've got 10 different presiding elected judges. They each have an associate judge. Every court has their own policies. And all judges kind of have their own little, unique quirks, the things that, might bother one judge, wouldn't bother another. And so that's another reason why every case is different, is that it depends on what judge you're in front of. We also have 2 new judges that are on the bench as of January 1st. And so, they might kind of still be figuring it out, what their preferences are and what works best for them in their court.
Okay.
All right, so moving on to the topic of child support then. All right, so we have several different types of child support. We have current child support, there's medical support, there's dental support, there's retroactive child support, and then temporary support. And we'll kind of go through each one of these a little bit more in detail. Now, the first thing is when it comes to calculating current child support, what the court will do is the court first has to determine the obligor or the parent who pays child support, what their monthly net resources are. After that, the court will apply the child support guidelines to that amount. And then the court will consider any factors that might justify a deviation from the guidelines and then adjust as appropriate. And so when determining the net income of the parent who's going to pay child support, the court will look at 100% of all wages and salaries. The court looks at dividends, royalty income, self-employment income, net rental income, and then we've got this kind of catch-all caveat of all other income actually received. And so that can include retirement benefits, gifts, severance pay, pension, unemployment benefits, workers' comp, and even prizes. So if you win the lottery, that money can be used towards child support. Resources that the court cannot consider when coming up with the net income is the return of principal or capital, accounts receivable, benefits paid in accordance with the Temporary Assistance for Needy Families program or another federal assistance program, and then the payment for foster children. There are several required deductions. So the court will look at all the income, like I mentioned, and then we'll deduct only the following items to come to the net monthly income. And so that's Social Security taxes, federal income taxes at the rate of a single person claiming one personal exemption and the standard deduction. State income tax, we don't have state income tax in Texas, but if you have a parent who's living in a state that does, that's taken into consideration. Union dues are taken into consideration. Expenses for the cost of health insurance and dental insurance or medical support of the child. So we'll cover that in a little bit, but a parent will get a credit for whatever they are paying either for monthly premiums or to reimburse the other parent for monthly premiums. It's not a dollar for dollar credit, but it's still helps as far as the deduction goes. And then if the paying parent does not pay Social Security taxes, but instead has a required retirement plan contribution as part of their employment compensation, then that is deducted as well. Then after that's been deducted, the court will apply the child support guidelines. This is the breakdown. It's also worth noting that if the parent has other children who are not part of this case, so if they have children from another relationship, then these amounts will adjust and they'll be less. And again, just in the interest of keeping things kind of simple today, I didn't want to go through all of that. Additionally, these guideline percentages are only applied to the first $9,200 of the obligor's monthly net income. And so if you have a parent who is making, $15,000 a month, then initially the court only applies this to the first $9,200. You can ask the court for above guideline child support, and we'll kind of get into those factors in a minute. It's also worth mentioning that there's a presumption that everyone has the ability to earn a minimum wage living at 40 hours a week. And so usually at the bare minimum, the court will apply these percentages to a minimum wage salary. However, if a party is able to show the court that they are making less than the minimum wage, actually making that much, then the court will apply percentages to that lower amount. And also recently, the legislature came out with a different set of percentages that are applied if a party can prove that they are making less than $1,000 a month. Now, again, when it comes to child support, there's a presumption that the amount of child support that is set up in the child support guidelines is presumed to be reasonable, and an order of support that conforms to the guidelines is presumed to be in the best interest of the children. However, a court may determine that the applications for the guidelines of child support would be unjust or inappropriate under whatever specific circumstances are happening in that case. And so some of the factors the court will consider is the age and needs of the child, the abilities of the parent to contribute to the support of the child. So maybe if the parent is paying for something in addition to child support, any financial resources available for the support of the child, childcare expenses, whether the parent has any other children that they are a managing conservator or have actual physical custody of, the amount of alimony or spousal support that is actually being received, any special or extraordinary educational, healthcare, or other expenses of either a parent or the child, the cost of travel to see a child. So if you have a parent who has moved out of state, has moved the child out of state, sometimes the court will give the parent who remained where they were whenever the first order was entered or before the case started, we'll give them a bit of a break because it's going to cost them a lot more than just, driving down the road to go pick up the child. And then any other reasons consistent with the best interest of the child, taking into consideration the circumstances of the parents. And so again, that's kind of a catch-all that allows the court to really consider just the totality of the circumstances, and also the amount of time that a parent is actually seeing a child. And so that goes both ways. So if you have parents who are doing more of a 50-50, then the court can deviate from the guideline amount. On the other hand, if you have a parent who's not even exercising, 1 weekend a month, the court can raise their child support to give that other parent a break that they don't get because the child's not going with the parent every other weekend, essentially. Some factors that the court cannot consider when it comes to child support is the paying parent's history of voluntarily paying above guideline child support. So the court can't look at a situation and say, well, mom had been paying dad more than what I can order her to pay, so I'm just going to go ahead and continue doing that. The court also can't take into account the sex of the parents or the child, and then the marital status. The court also can't take into account the income of a stepmother or stepfather. Now, when it comes to medical support and dental support, that is in addition to child support. The court will order a party to provide health insurance. And if that party is not able to provide it, then the court will order the party who's been ordered to pay child support to pay what we call cash medical support or cash dental support. The priority for the court is that they prefer to have the parent who's been ordered to pay child support provide health insurance through their employer. And again, whatever it costs, that parent gets a little bit of a deduction each month when it comes to the child support amount. If the health insurance is not available from a private insurer for the parent who's been ordered to pay child support, then the court can order the parent who's been ordered to pay child support to either go out and get a plan to do government assistance, or to have the parent who is receiving child support continue to provide the health insurance if it's available to them at a reasonable cost. In that case, the parent who is ordered to pay child support will also pay cash medical support to the other parent. Now, when we say reasonable cost, I know that sounds kind of vague, but the Family Code has defined that for us. And so the total cost of medical coverage for the child cannot exceed 9% of the obligor's annual income. And then for dental coverage, cannot exceed 2%. Another thing to keep in mind is that whatever the court does as far as ordering health insurance for the children, the court's going to want to make sure that medical care is available under the insurance within a reasonable distance from where the child lives. So if you have a child who lives up in Conroe, it's not fair to the child if the only doctors covered under a parent's health insurance plan are down in Galveston. Then retroactive child support. So the courts have the ability to order child support going back before a case really got started. It doesn't happen all the time, but it's possible. It's up to the discretion of the judge whether they order that or not. In order for a court to be able to order that, they have to show that child support has not previously been ordered to be paid, and that the party there was not a previous lawsuit involving these parties where they had agreed not to do child support. If the judge does decide to order retroactive child support, they will do it again based off of the guidelines and calculate it based off of the guidelines of child support for what the parent was making at that time. So if a year ago, the judge wants to order retroactive child support for then, and mom was making a lot less money then, the court will take that into account when calculating the retroactive as compared to the current child support amount. And again, the court can go back to the date of separation of the parties. Now, the duration for child support. So child support generally goes until the child turns 18 or graduates high school, whichever is later. Or if a child is emancipated, either through marriage or through a legal case. If a child passes away, the child support obligation stops. Or if the child is disabled, the child support can continue for an indefinite period. Now, with the indefinite child support for a disabled child, a party or a parent has the ability to ask for payments to last indefinitely if they can show that the child requires substantial care and personal supervision because of mental or physical disability. Essentially, the child, is unable to care for themselves. That the child will not be capable of self-support because of it, and that the disability or its cause is known on or before the child's 18th birthday. This kind of request does not have to be done and heard by the court necessarily before the child's 18th birthday, but certainly the sooner the better. You just have to show that the injury or whatever caused the child to be mentally or physically disabled didn't occur after the 18th birthday. And then when it comes to modification of child support, again, modifications are, a whole nother bag of worms. And so we could spend all day, but just generally the grounds to modify a child support order are by agreement. And when you do it by agreement, you still have to show the court that the change in child support is in the best interest of the child. There's also kind of a general 3-year rule. So once child support has been set, typically we come back every 3 years. It's possible to come back sooner, but we come back and recalculate child support to see if there needs to be an increase or decrease. And then again, if there has been a material and substantial change in circumstances from the date the order was rendered or from the date that the parties signed a mediated or collaborative law agreement that the order is based off of. And that is the end of my talk on child support. Do we have any questions about that?
I actually had a quick question.
Sure.
In regards to retroactive child support, if you've got a non-custodial parent that can show proof that they've been making payments even prior to an actual order, is that taken into consideration when an order is put in for retro child support?
Yes.
Okay.
So yeah, if they're providing, shoes, diapers, clothes, food, anything like that, that is taken into consideration. Kind of on the same lines though, if later on when it comes to modifying or if there's an enforcement, there's going to be pretty much in every order a provision that says that any payments made for food, for anything like that, clothing, is in addition to and not in lieu of the child support that is ordered to be paid through the state disbursement unit.
Mhm.
And so a party is not entitled to informal or credit for informal payments. So if a party is ever ordered to pay child support, they need to make sure they're doing it exactly how the order says and paying it, and it should say pay to the state disbursement unit, the Office of the Attorney General. Otherwise, they might not get credit for if they're handing, a check every month to the other parent or even cash. Because the Office of the Attorney General keeps really great records for everybody as to who's been paid and when.
So keep receipts.
Yes.
Keep your receipts.
I
Definitely.
have a question. What if someone is working out of the country in the armed forces or so, let's just say armed forces, and their child is with them in that other country, but their home is here in, let's say, Texas. And then the spouse that lives in Texas files for divorce while is there a process that someone, while they're in the armed forces or working out of the country, that would be different than it would be a normal child support custody, correct?
Yes. So you're making me scratch my brain a little bit here. So I don't do a ton of military work. I know there are some attorneys here in the area who are much more versed in that than I am, but we do have special laws, and off the top of my head, I cannot remember exactly, but when it comes to military families, because obviously sometimes they have to move around a lot, whether they're going from base to base or out of the country. So when it comes to jurisdiction and venue, we've got some special rules as far as they're concerned. Additionally, if you have, say, a parent who's trying to start, a highly contested custody case while another parent is deployed, the parent who's deployed can file a motion with the court and say, hey, look, I'm over here serving our country. We need to hit the pause button until I can come back. And pretty much all of your judges are going to do that.
Awesome. That's because we've received a couple of emails, Nia and I, concerning they're deployed, and then there's some others that are working for the United States government, but they're working, in different portions, but not in the as a soldier or anything, but they're still working out of the country representing the United States government. And we just wanted to confirm, but it's still, they can pause it until they come back.
Right. And a lot of it is just don't ever just kind of, take a head in the sand kind of approach.
Mhm.
If a case is started and you're not able to physically be here, it's a lot easier nowadays, especially with Zoom. Pretty much every court, if you file a motion and say, hey, I have to appear via Zoom for this hearing because I'm in Kuwait or wherever, your court's probably going to let you. And again, if you need to hit the pause button because you can't be here, a lot of the courts will do that as well. One thing to keep in mind, so there's also special rules as far as parents who are deployed in the military. They can actually assign someone else to exercise their visitation for them while they are gone. Now, people who are overseas or are in jail or overseas for, private contract work or are in jail don't have that ability. But we have a special exception for our military men and women.
Okay, fantastic.
Yeah.
Now, was there anything else with that? Because I know you and I had received some emails on that.
Not on that one, but I did have a question about medical expenses. So if you've got, the whole order is in place as far as medical insurance and things of that nature. Outside of the medical insurance, if there are expenses related to medical procedures or whatever, if a parent does not agree with whatever the procedure is, how does that get worked out? Or a medical treatment or something to that nature. How does that get worked out?
So a couple kind of different things there. So first off, when it comes to a parent agreeing or consenting, that's where it goes back to the rights and duties. So if the parent doesn't have the right to consent, if one parent has the exclusive right, then the other parent doesn't have to consent and they can still be on the hook for paying the cost. Now, when it comes to support, either a parent is providing the health insurance or paying cash medical support for the health insurance. But as we know, that doesn't cover everything. And there's always uninsured expenses like copays or prescription costs. And so thank you for bringing that up, because that was something that I had unintentionally left out of the presentation. But in every order, there's a provision in there that says how that's going to be handled. And the standard is doing 50-50. So if mom has the child gets an ear infection, she's got to take the child to the doctor. She goes ahead and pays the copay. So let's say the copay is $20. Then what she'll do is she'll come home with the receipt and send it to the other parent. And then that other parent has 30 days to reimburse mom $10. And so that's the same with any kind of prescriptions, copays, any kind of deductibles, all of that fun stuff.
Okay.
Ms. Kelly?
So on that, we've had some issues, and for instance, like, okay, you pay the copay, but then it ends up processing for like dental, let's say. You pay whatever's up front, insurance processes it. Then I end up providing the receipt after it's been processed because it's a different amount.
Mm-hmm.
So it doesn't have to necessarily be 30 days from the procedure, does it?
It's better to do it 30 days from the procedure, because then if it's not paid, you have more abilities to enforce that payment. Either way, the uninsured medical expenses are a little bit harder to do enforcements on. I like to call it like a Texas two-step, because you have to go and get a judgment first with the payout. And then if it's still not paid out, then you go back again. And at that point, you can ask the court to award jail time for non-payment of that judgment. But when it comes to just these, because every month is different, some months you might have
Yeah.
several copays, some months you might have none. And so with that, we
Well,
kind of
like-
have to do a two-step process.
Okay, so like for this instance, like it's a really big example in my situation is my son ended up having like 10 cavities, terrible, like back and forth. Oh, and this was over about a year and a half. Paid, the $200, $300, whatever. Well, then it processes, and it's like, oh, well, now we have a credit at the dentist. So then, then we go in the following month and then have to end up paying, and then that credit goes towards it and comes back and forth. So like 9 months in, we finally get the actual amount. So that's when you still have to probably just follow the two-step.
Yeah, and I would still tell you, go ahead, just as soon as, you get the receipt that you pay the initial amount, because if there is a credit later on the account, you can apply that to future expenses, with the dentist or doctor, whoever. Now, in the situation that you ever get an actual check in return from the doctor or the dentist, that does need to be split with the other parent, assuming that you guys have been splitting everything 50-50. But as long as it stays with the dentist or the doctor, whoever, you can apply that to future expenses, and that way it covers, makes what the parents have to pay at that time a little bit less.
Okay, thanks.
You're welcome.
Are there any other questions?
Those are all the kind of questions that I had off the top of my head, but I did just want to kind of make a comment and kind of to reiterate what you were saying at the beginning, that everybody's situations are different, everybody's circumstances are different. And please believe, we personally understand that the whole child support, child custody is a very sensitive subject matter that a lot of people are experiencing a lot of different things. And for someone that had put a comment into the chat that I actually deleted. So we're not trying to make this the platform for you to make your arguments about who's doing what and so on and so forth or whatever. We're just here just trying to explain what the law is and what the process is. So if there's some additional assistance that's needed where you need to file certain complaints and this, that, and the other, that's a whole nother subject matter altogether. But I just didn't want to just kind of roll over that, because I want to acknowledge that I saw the comment there. However, this isn't the platform to actually to do that. And I do want to make sure that gets recognized. Ms. Carey says, I have a question about child support. You want to go ahead and unmute yourself?
Yes, how you doing? It's actually Mr. Carey.
I'm sorry.
No, it's fine. This is just more of a follow-up. Grace, you had mentioned something about after 3 years that the court may look to, is that recalibrate what you're paying? So like, say for instance, I just got recently divorced. We have our child support agreement already signed off, everything like that. Like, are you saying like in 3 years now that they'll go back and look to see if I should be paying more, or what? Could you elaborate a little bit more of what you were saying on that piece, please?
Sure. So it's not an automatic thing. That's just when a party is allowed to come back and ask the court to modify the child support, because it's been 3 years. And so at that time, each party will have to produce their financial information. And child support is just a calculation. However, anytime that you do file a modification, even if it's just for child support, you do open the door to also modify any kind of conservatorship or possession and access. But yes, to answer your question, it's not an automatic thing. So the court's not, sitting around with the list of cases that are turning 3 years old saying, hey, we need to reach out to these people. The OAG will do that a little bit. So the Office of the Attorney General will, if you have worked with them, and they'll actually do it at no cost to you. But they do tend to, move a little slower because they do have so many cases.
I'm sorry, and I have just one more question.
Sure.
It's regarding, so say for instance, the other party, right? The other parent that isn't received, that the other parent that's receiving, the mother, right? She's receiving child support. Let's just say like in about 5 years or so, I know you had mentioned something about, say they won the lottery, or better yet, a better case scenario. What if they inherited, like they have a trust fund, they inherited a trust fund and they came into a lot of money? Can that other parent that's paying the child support look to maybe offset that or what they're paying or something like that? Is that something that?
No. So when it comes to calculating guideline child support, we don't look at the income of the parent who would be receiving the child support. Now certainly if, a parent is asking to, do above guideline child support, yet they've got, more money than they know what to do with as far as taking care of the child, then obviously the court's going to take that into consideration. But just in general, in calculating child support or modifying child support, the court's not going to look at the income of the receiving parent.
Okay, thank you.
You're welcome.
Okay, good question. Let's see if there was anything else here that I missed in the chat. No, there isn't anything else in the chat. I just wanted to double check to make sure that there wasn't anything else that I had missed. Double check this files.
Now, you know what, Nia, if they have any other questions, or if they think of any other questions and they want to leave their names out of it, they could email amoshouston@gmail.com. And we can, when we get Miss Grace back in here, we can kind of send her the questions and then she can be prepared for some of the questions that you might have thought about. Nia, what's the email that they can send them to?
It's either the amoshouston3 at gmail.com or to myself or to Myra. When I send out the email link, you can send them to Myra and myself as well too.
Mm-hmm. Because next time Miss Grace comes back, which we promise you she will, because all of y'all, when you leave here, you'll go, oh my God, I forgot this question. So write down your question and then email it to us, and then we'll send it to Miss Grace, and then she'll be able to answer those questions if she can. Now, remember, this is not legal advice. We're not giving any legal advice. This is just for informational purposes.
So, Ms. Grace, how about your contact information? If someone's interested in you, you can go ahead and provide your information into the chat as well.
Sure, I will do that. And I'll go ahead and just tell you. So usually I direct everyone to my website, so I will put that in there, and then also my office phone number.
Go ahead and say it aloud for the folks that are on Facebook that can't see the chat.
Oh, sure. So my website is, I typed it in wrong. It's crumpfamilylaw.com. And then my office number is 281-974-7104.
Okay, so if there are other resources that you know of that, in case of, other than we talked about Harris County Domestic Relations, if someone wanted to reach out, like if there's a service or assistance for fathers or single parents or whatever, are there services that you guys are aware of that can assist the community with some other kinds of resources as well?
So the Harris County Domestic Relations Office is going to be the big one. They're constantly adding new programs and new things that they're doing. Like I said, they do have the visitation center. They also do, I believe they're doing parenting facilitators now. So what that is someone who's kind of like a referee. So if you've got two parents who just really can't agree on the time of day, it's somebody who will help them kind of see the other person's side and see if they can't come to an agreement. It's not binding. They're not, the facilitator's not making any decisions for the parents. Like I said, they're just kind of acting as a referee. They also do custody evaluations for us. They do adoption evaluations. They've got parenting classes as well, I believe. They're like I said, they're constantly kind of like changing and doing new things just depending on what the need of the community is.
Do they have I've heard one of my other friends that have a for the parents that don't communicate or cannot talk, there's like an online portal where they're supposed to
Yes.
actually have their communication through, as opposed to, what is that called? I can't.
So yeah, there's several. So the big one is called Our Family Wizard. And that one, it's subscription based. So I think it's about like $100 or $200 a year per parent. And it's got like a lot of bells and whistles. There's an app that can go on your phone. You can pay. We were talking about the uninsured medical expenses. You can actually track that and pay it through the Our Family Wizard app. There's a message board. So the parents will send messages back and forth to each other. And the good thing about the message board is once you send something, you can never delete it. And so if one parent's being nasty, it's there forever. Additionally, it tracks when a message is sent, the first time it's viewed, and then when any response, it'll timestamp any response. So if a parent is just opening messages and never responding, you're going to have track of that. It's also, you can print out everything that's on there in the Our Family Wizard portal. So it's just a portal between mom and dad. Nobody else gets to see it, but you can give your lawyer access to it if you want. And then the lawyer can go in there and download everything. So all the messages, all the pictures that are posted up there, all the expenses, the lawyer can easily download it. And then it's presumed that that's going to come in, that we can use that as evidence in court. And so it makes my job a little bit easier sometimes. So I don't have a client who's having to screenshot all their text messages or figure out how to download their text messages. I can just request access, go in there, click a few buttons, and then I've got pages and pages of messages between the parents, talking about everything from, getting to baseball practice to doctor's appointments, all of that.
So when it comes to the visitation schedule, if you're supposed to be at a certain place at a certain time for drop off and pick up, and somebody is either constantly late or don't show or whatever, what's considered to be a reasonable amount of time that you're supposed to wait for the other parent before you just decide, okay, I'm leaving. I'm not going to wait.
So it's kind of an unwritten rule that we give a 30-minute grace period. But especially, I always tell my clients, if the other parent reaches out and says, hey, look, I got a flat tire, or, I'm stuck, there's a really bad accident on 45 or whatever, work with them. It's for the benefit of the kid at the end of the day. But if I tell my clients also that if dad's supposed to pick up at 6 p.m. and it gets to be 6:30 and he's not there, and you haven't heard from him, you are free to go about your evening and go do whatever you want. And it's deemed that he has waived his period of possession. Again, I always tell my clients, work with the other parent as much as possible. I had kind of a really nasty custody case a couple years ago where, dad was running late one day. He texted mom and said, hey, I got stuck at a train. I'll be just like 5-10 minutes late. And he gets there and she's just like, nope, sorry. You're late. I don't have to release the child to you. And although legally, she was more or less within her rights, it just didn't look good. And the judge wasn't happy with her about it.
Okay, good. Ms. Corkin, and then we have another question too from iPhone. Go ahead. Kelly?
Yes. On the Our Family Wizard, I don't know, maybe I should be asking Our Family Wizard. Is it something to where if you give stepdad or stepmom your
I think you cut out.
Did we lose her?
Miss Pam? Let's go to the next
I'm
question.
sorry, I have terrible reception.
There you are.
Okay.
If maybe I should be asking Our Family Wizard, but if stepmom or stepdad have access to Our Family Wizard, are they able to log in, or is that something that can be seen on the back end, if it needs to be in the end?
It depends. So really the court is going to prefer that it's, the parents talking to each other and not having, the step parents be a go-between. But again, every case is different. So sometimes, mom and stepmom are able to better communicate for the benefit of the child than mom and dad are. And so ideally the court's going to want just the parents communicating and co-parenting together. But if no one's complaining
Yeah.
about the fact that mom and stepmom are talking, or dad and stepdad are talking, or whoever, then the court's not gonna have a problem with it.
Okay,
Okay, well, this is, I guess, an issue to where it's being pushed. And the co-parent won't actually co-parent.
Okay.
So I was
And
just
yeah,
trying
I
to
mean,
see, I
that,
was just curious if our family wizard, like if it's actually to where it's set up to where it's a 1-for-1 access. Does that make
You can-
sense or something like that?
you can add, so I always have I tell my clients not to. I mean, you can add step parents, you can actually even add for the children as well. But really, I think the judges prefer that it just be a communication tool between the parents.
Okay. Okay, thanks.
okay. There's iPhone user.
Hi, I really have a question for you guys. You guys are recommending Harris County Domestic Relations Office. They are getting paid by Office of Attorney General and hello.
Yes.
Yeah.
Go
You guys are recommending Harris County Domestic Relations Office, and they are getting paid by Office of Attorney General and the taxpayers. All they are doing is taking a man out of the lives of the children's. And I'm doing a study.
No, we're not gonna do that. Again, this isn't the platform for you to voice your complaint about your particular caseworker or your particular situation. So however it is that they do, whatever it is that they do, again, your particular situation is completely separate and different, and it is not the norm. So we'll be happy to kind of put you in contact with somebody at Harris County Domestic Relations to voice a concern or complaint or what have you, but we don't want to use this platform for the complaints. This is, again, just for educational purposes only, for the folks that are here that want to know what the process is, what the law is, and where it is that they can actually go for other resources and services. So I do apologize that you've had the experience that you've had, but we cannot, use
And-
this as that platform.
And Ms. Nia, just to remind everyone, this is all for informational purposes, just like Ms. Nia said, and I was the one that muted you. We will mute anyone right away if you're complaining, arguing. Everything that we're doing right here is for informational purposes only, and that's it. But if you have a concern, go ahead and call that office and discuss your concern with them. Thanks, everyone.
Ask for supervisors or whomever, and go through the formal process of filing the complaint. But we don't have any control over that. So, and we don't know what happened or what everybody's situation is like. So we don't want to kind of get into that, here. So,
No, we're not.
are there any other questions of anybody else that's participating? I
do want to mention, just kind of,
Go ahead.
not trying to open a bag of words, so kind of along those lines. So there is still kind of a misconception that moms are going to win no matter what because they're moms. And yes, maybe 20, 30 years ago, that was, I'm sure, very much the case. I was not practicing back then. But nowadays, from my experience, I've been practicing for 11 years now. And like I said, I represent moms, I represent dads, I've represented grandparents, I've represented aunts and uncles. And in my experience, your courts, especially here in Harris County, take that requirement that they not consider the gender of a parent or the child. They take that very seriously. And, really, again, in my experience, the courts do act in the best interest of the children. And so sometimes that might mean that the children should be with mom, or sometimes that might mean the children should be with dad. Sometimes that means the children aren't with either parents, they should be with grandparents. And so there, like I said, there is still this misconception that dads are going to get a rough shake in family courts, and that just hasn't been my experience.
That's kind of also why I was asking about other services or resources that were out there for, for like dads that kind of feel that way or whatever. Is there like a group or some kind of resource for them?
I know there are. I can't think of any off the top of my head. dad's rights is kind of another hot topic issue. And so there are groups that, you know, are lobbying the legislature to try and get more rights for fathers. Again, personally, it's been my experience. I don't think that's necessary, but I can certainly understand how some people might feel that, you know, they need to have a voice.
Mhm. And you know what, in one time or another, we've all felt that way. And there's a process to every situation that we're all going through. So don't ever forget, and don't ever think that you're by yourself. There's a process, and everyone has gone through one process or another. So find a group that can assist you in whatever stressor you're going through in your life. Ms. Nia?
I believe those are all the questions and or comments that we had in the chat session.
Yes.
So with that being said, Ms. Grace, thank you very much. You've gotten a couple of compliments here on Facebook too. So I was going through to make sure that, you know, there weren't any questions that are posted here, but great job, Ms. Grace. Lots of hearts, emojis and things of that nature. Yeah, other topics will be so great. Thank you for passing this information along, so on and so forth. So thank y'all very much. Really, really appreciate you taking the time out for volunteering today to provide this information to the community. Again, this session is being recorded, and we will send out the link to everyone to go back to watch the presentation again. You can also watch live or forward to someone else that share on Facebook or on our YouTube channel, and I will include all of that information in the email when I send it out to everybody. So again, we provide this information to the community because we know that there's a lot of folks that don't have access or have these questions and don't know where to go, how to start, who to reach out to. Ms. Kelly, you unmuted yourself again. Was there a question? Oh, okay, I think we just lost it. Okay, but again, we ask that you guys to pay it forward. Please feel free to share this information with everybody else that you feel that may find this information to be beneficial. We appreciate you guys for coming back and participating and continuing to support a month of service. Thanks to our volunteer attorneys, and please understand that the attorneys that do present here are volunteering and taking their time out of their schedules to provide this information to the community. So we really, really appreciate you guys for doing that, because you know, this is your prime time billable hour, you know, time frame. So we appreciate you taking the time out. So with that being said, you guys have a wonderful remainder of your day. Ms. Grace, once again, great having you here, and we look forward to coming back, and maybe we can do like a dad's
Sure.
segment or something like
great.
that. You know, maybe
Yeah.
that dad's father's rights or something like that. So I think that's it. Is there anything else, Ms. Myra, you'd like to include?
Just remember that if you have any questions, like if you're watching TV and you think of any other questions, please make sure you send it to myself or Ms. Nia or AmosHouston3 at gmail.com, or send it to us on Facebook, YouTube. We're always monitoring all our social media sites, Instagram. So if you have any questions and you're on your own time, just send us an email and let us know. And we will definitely ask Ms. Grace, have her back. Thank you, Ms. Grace. Wonderful job.
Thank you for
Okay.
having me. And thank you again for everything that you guys do for the community.
Thank you. So for future reference, this Thursday, we've got our inherited property clearance title presentation that's going to be on Thursday. So you guys can join us for that on Thursday at 1 p.m. Next week, Tuesday, we have our evictions. We know that people are still experiencing those financial hardships as far as rent goes and things like that. So we've got our eviction presentation for our homeowners. We've got our maintaining and adding value to our home. That's coming up, as well as, again, coffee and conversation on April the 25th. Property tax protest and valuations workshop is going to be on Wednesday the 26th, and HOA foreclosures is going to be on April the 27th. So we invite you all to come back and join us for any one of those. If there are other presentations that we don't currently offer that you guys may be interested in, please feel free to drop us a line there also. That's the only way we kind of know what it is that the folks will want by you guys communicating with us and letting us know what's a hot button issue for it that you'd like for us to present to you. So definitely keep us updated there. But again, thank y'all very much. You all have a wonderful remainder of your afternoon, and take care of yourselves and be safe. Thanks.
Bye, everyone. Thank you.